first case that's going to come before us is State of Ohio versus Robert Papotto.
Right.
Papotto, okay. Sorry, I'll try to speak up. Papotto.
Oh, I agree.
Okay, I just saw you going like this. I want to remind both individuals that you have 15 minutes to present your arguments to the court. And Mr. Papotto, you as the appellant will have 15 minutes, but you can reserve up to 5 if you want to, present something in response to what he argues, okay? So you just have to let me know. We are filming. This will be released on our YouTube channel, so we need to have you stand right in back, in front of the podium there for us to see you and for the camera to see you. And if there are no questions, we're ready to proceed. All right, you have 15 minutes. Do you want to save some time?
Yes, I do. I'd like to reserve my 5 minutes.
Okay, sounds good. And on the monitor over there, there is the time, so if you want to see at any point in time how much time you have left, you'll be able to see it.
Okay, thank you.
Thank you. You may begin.
Okay, thank you. Good morning. I'm here today to ask this appellate court to take a look at exactly how this case was brought against me and presented in the trial court. Lisa Coates was the presiding judge in that case there. And I have also filed a motion to set aside a decision by Mike Walsh for the correction of the record, which I've done a lot of things. I'm not sure of all the rules and things like that, but that was granted by the judge. He sent that over to have the record corrected. And if you if you can't understand that, then there's something wrong with you. And I'd like to say, excuse me, that's not my words. That's what Lisa Coates told Brad Bryan when she thought I wasn't listening. That's why I'm here, because I was biased against from the very beginning. When I got to the courtroom that day, both Judge Joe Kodish and Tim Corley were sitting outside the courtroom, and there was an accident. I was concerned about being on time, and they tried to stop me, and when I walked past them to let the judge know I was there, she screamed at me, "Who are you?" And I told her who I was, and she said, "Get out of my courtroom, I'll let you know when I'm ready for you." Well, Brad Bryan was in there with the judge, and I think that's inappropriate for him to be in there talking with the judge, possibly about a case that could be pending in their courtroom. Well, when I went back into the courtroom, she screamed at me, "You're wasting the court's time. You better get out there and listen to your attorneys. I got tickets for a conference I'm not going to miss because of you. I got the tickets that are already bought and paid for. We can't afford a lawsuit brought against the casino." That's extremely biased. All of that has been scripted from the record. I don't know if I'm saying that word right, but when I asked for a copy of the transcript, all of that stuff was taken out. Things that she said to me that she didn't want to be in the record, they stopped that, they cut it out. And that might be good now, but the next step is for me is the disciplinary board, because I do have the evidence that proves what I'm saying is truthful, factual, honest, and fair. I did not get a fair trial. I was originally...
Could I stop you just for a second?
Sure.
You said that the transcript doesn't reflect any of the statements that were made by the trial judge.
Well, they're cut out, they're scripted from that. But I have affidavits from a witness that I had 4 people that came to the period court with me. They all heard what was said, Judge Carter. They heard what she did. And I don't know if I can make a motion orally now to set aside Mike Walsh's decision, withhold that from the record.
Affidavits is what you moved to have admitted?
Yes, I do.
We can't consider them.
Well, it doesn't mean it's not true.
No, I'm not saying that, but I'm just saying we can only consider.
And another thing, and this is I'm accused of what I'm doing right now. I'm trying to present my case. I don't know what I'm doing. I'm a disabled carpenter. And 10 years ago, my very first visit, that's in the transcript, they told me 2 weeks after I saw the state doctors, I never had a doctor's report of my own, that you're done, you can't work no more. I had no idea what was wrong with me. Everything that they told me was severe and final. I don't look like it. That doesn't mean it's not true. Severe arthritis in the hips, severe spinal stenosis. My right shoulder is irreparable, it's bone on bone. I'm diabetic. My guts popped out. All of this happened at one time. They had to push her back in. I had a Cleveland doctor when that told me. I was lucky I got there when I did. So I live in constant chronic pain. So they interpret that as aggressive. And the video from the casino proves that everything I said about what happened is true. But Brad Ryan, he wanted to interpret that as, how does he say, I'm the aggressor, he says. And another thing that police codes didn't allow me to do was present all my evidence. So Mike Bonfield was the testifying witness for the city of Northfield Village. You know, I have trouble calling him a police officer because his conduct is horrible. And I'm just calling him, and 6 year at that time, he was 6 years, he's 24 years old. That means he got on there when he was 18 years old. And if you watch the body cams that are admitted, they only let me admit 2 of them. There was 4 police there, not 3. And each one of those body cams depicts something different. And there is times where they're, with that attorney, Tim Corley, say, repetitive. Well, there is, but why would you not allow me to present Mike Bonfield's body cam when he's the testifying witness for the state? So they originally gave me a disorderly conduct. I think it was 646.04, I believe it was. I can't remember, but they gave me they gave me a disorderly conduct, me and only me. Now, I don't understand how that happens when the video clearly shows that I'm the one standing at the kiosk with my back to their witness, Willie King. Well, he gets frustrated, and Brad Ryan knows during the arrest, when they arrested me, that, Ed Carlisle was supposed to be the supervisor for the Northfield Village Police Department. While I had my back to the video talking to Brad Ryan about what was going on there, I thought maybe he would do the fair and right thing. Ed Carlisle tried to start that in a different direction. I've got that arrest video as well. I have all the evidence. For him to say Tim Corley knew what was going on because of a timeline, you could look in his files right now. He don't have a thing. All of that information he had was the information I gave him from gathering the evidence, because I knew what they were doing to me wasn't right. So they charged me with the disorderly conduct, me and only me, even after their witness admitted to 2 different police, Zombach and Zindicki. Zombach tried to lead him into the testimony. Well, oh, he invited you outside. And then their witness, Willie King, said, no, I invited him outside. Well, I had no intentions to go out and fight. And because my method of trying to get a hold of the surveillance team which I didn't know. They thought I was an asshole until I watched Mike Bonfield's body cam, and it's clearly, they begged this guy to file an assault charge on me, and he wouldn't do it. A week later, when Bonfield signed an affidavit, made an affidavit for assault, and when you look at his, if you look at his, I got so much stuff highlighted on here. When you look at Mike Bonfield's affidavit, oh, here it is right here, number 6. The wording on that is clearly questionable. When he states that the victim came down to Northfield to sign a statement. Well, I had to think about that. Not only did they allow him and Bonfield to sit in the courtroom while they showed the incident, because that's a prearranged deal that Brad Bryan made with Tim Corley. I had no idea what was, I didn't even know May 24th was my pretrial, that James Bernhardt just introduced himself, and I couldn't believe what they were doing to me, and he said, well, just sit here, I'll be right back. And he wanted my evidence. I said, no, you get your evidence from the state. So
Yes, sorry, Mr. Papotto, I want to make sure that you save your time. I was listening to you, and it's now 4 minutes, so if you want to save the rest of that time.
Pardon me?
Would you like to save the rest of your time now?
No, I get 15 minutes, right?
No, you get 10 minutes and then 5 minutes for rebuttal.
Yeah, so I only got 5. I got 5 left, right?
Yeah, but I thought you wanted to save that to respond to his argument.
No, I get total of 15, correct?
A total of 15, so you
So I
have
can
now
go
4
10?
minutes left.
Yeah, so I got 4 minutes left, so I can go that, and then 5 minutes to
No.
rebuttal his.
No, that's what I'm trying to tell you. You have 15 altogether, including the 5.
Oh, so I only have that
Yeah, I'm
left.
sorry, I should have notified you.
No, I was I'll see.
That's okay.
I went on.
I was listening and not paying attention to the time too. so.
Well, I went on a tangent because there's so much wrong with this. There were so many things that the trial court erred with that I'm trying to dot every I and cross every T. I'm a disabled carpenter.
I know you said that.
And,
Okay. All right, well, you'll have 4 minutes from me.
well, maybe after I hear what he said, I'll be better prepared.
Okay, thank you. Oh. Thank you. I guess we can have our microphones on either. I don't know if this is any better. Okay, yeah, 15 minutes.
Good morning, panel, your honors. May it please the court, my name is Brad Bryan. I'm the director of law and prosecutor for the village of Northfield. Mr. Papotto, as the court's aware, first assignment of error argues that during the course of the trial, the court acted prejudicially toward him. Specifically, he states the trial court was hostile toward him, was aggressive toward him, and the trial court was in a hurry. He states that those actions violate the first 3 canons of the judicial ethics, and essentially, I think what he's stating today and stated in his brief is that the trial court did not give him a fair trial. The state contests that argument, and I think a full reading of the transcript shows that he was able to present his case in the manner he wanted. Really, the only grounds in his brief in support of that first assignment of error are the extraneous evidence that was presented and contained in the attachments to his brief that were deemed improper and stricken from the record. I think if the review of the transcript shows that he was treated with dignity and respect during the course of the trial.
Counsel, just for procedural purposes, so you filed a motion to strike the appendix?
The additional affidavits.
Yes.
You did file a motion to strike that?
Yes.
And so then our court granted that to our magistrate?
That's correct. Right. So that's not something that should be considered by the court. And
record to back it up or not. It sounds like the things that he's alleging were, comments were made before the recording device was turned on.
That's correct.
So they wouldn't be in the transcript.
Correct.
So what is a defendant supposed to do in those circumstances?
File the proper procedural motions to have it added to the record. And I think that was the grounds for striking from the record, that the time they were trying to, he just attached them to the brief without going through the procedures of adding additional evidence. And there were several attempts to do so before the briefs were filed, and the magistrate ruled on those motions. And I think a couple of them directed Mr. Papotto to the rules for doing so. And they weren't followed, he didn't do so, and just attached them to his brief. As you can imagine, during the beginning of the trial, this wasn't the only thing that was set that day before the court. The court was dealing with other matters. I had another case that was also set for a jury trial that got resolved, so there were a bunch of things to deal with that didn't have to deal with Mr. Papotto's case. So I think that led to some of the kind of confusion as to what was going forward, what the judge needed to do before we started. But once the trial actually started, the full day was open. The defendant was able to present whatever evidence he wanted. If you look at the record, there wasn't any objection to any type of evidence the defendant, Mr. Papotto, wanted to present.
I didn't understand that. What did you just say? I didn't
There,
understand.
there wasn't any, he mentioned that he wanted to present additional body cam videos during the course of the trial and wasn't allowed to do so by the court. There was absolutely nothing that was asked to be presented evidence-wise
Well,
as far as the video.
but I think that's part of the allegation of ineffective assistance of counsel, though, isn't it?
I don't know if that's specifically stated in his brief. It's a little vague on the ineffective.
Well, he said the counsel didn't do anything other than just ask 4 questions during the trial, that's it.
Right, and that's the part, that was the one witness that was presented. He said to Officer Bonfield, only 4 questions were asked. Officer Bonfield wasn't the only witness. The victim, Mr. King, testified.
So we're going to see in the transcript there was extensive cross-examination?
Of Mr. King, yes. Officer Bonfield, no, and I think that was a strategy decision by counsel. And I think when you do read the transcript, you'll find out he was very prepared for the trial. He knew the timestamp times of the video portions of what he wanted to show.
I'm sorry for interrupting. What about the procedural aspects? There are a few procedural things here that I want to talk to you about. One is, you said he was adequately prepared. You don't dispute that he did file a motion 2 days before trial withdrawal.
I did not dispute that motion, but if you look at the actual motion to withdraw, the grounds stated in the motion was based on Mr. Papotto continually rejecting the public defender's office advice and expertise, and Mr. Papotto's lack of respectful communication with the public defender's office. So it wasn't grounds that he wasn't able to speak with Mr. Papotto and prepare, or that he wasn't prepared. And I think on the morning in question, no one asked for the motion to be granted. Public defender's office was ready to proceed, and Mr. Papotto didn't ask
Well,
for it.
it sounds like there was a lot of pressure put on him, though, to take a plea deal.
Again, I'm not aware, that would have been conversations with him and his counsel, and I'm not aware if the plea offer was made, and
Nothing was talked about on the record about the plea bargain?
I don't believe so. I don't.
Okay. Obviously, we'll read the transcript.
Right,
That's just-
I don't think there's anything about the plea bargain on the record.
At what time during all this process was that misdemeanor reduced to a minor misdemeanor?
It was reduced the morning of the trial.
Okay, so the only thing that was going to trial was a minor misdemeanor.
Right, so the plea offer to plead to that offense, that minor, was open for some time, but yeah, in the morning, it was actually amended after discussion with the victim to proceed on the minor misdemeanor charge, amended rather than the assault charge.
So what was he charged with initially?
Initially, on the date in question, he was given a citation for a minor misdemeanor disorderly conduct charge,
And that was elevated then, amended to a,
assault charge,
which was an M1.
which was an M1 after the victim came in and stated he had substantial injuries, and it was amended on the morning.
So, because I'm noticing that the judge gave Mr. Papotto jury fees.
That's correct.
Doesn't that sound a little unreasonable considering the prosecution's the one that amended it down? It wasn't his choice.
Yes, that was, something that was done by the judge and awarding the jury fees. But yes, we did amend it without his consent, that's correct.
It was a bench trial too, wasn't it?
It was a bench trial, yes, but the jury was there because we were ready to go forward with the jury trial. And that's the decision the judge made. I would note that that's not a subject of the appeal, but I acknowledge it. It was.
Anything else?
Just to point out, the judge in her making a ruling, on the record that day stated, she placed great weight on what she observed on the security video and reaching its determination. And I think that is really the most important piece of evidence in the case. That demonstrated what happened. I think testimony, the judge did even acknowledge that the victim did initially ask Mr. Papotto to go outside and fight, but pointed out that he quickly changed his mind, changed his direction from walking to the door, tried to walk away from Mr. Papotto, and he continually followed the defendant to continue the situation and was the first one to strike him. With the ineffective assistance of counsel, again, I think that the standard from State v. Smith and Strickland v. Washington, shows that he needs to demonstrate that counsel's performance was deficient and the performance prejudiced the defense to the point where the outcome would have been different if things would have been done differently. And I think, with the whole incident being on video, that was, what the judge was looking at, again, colored by the testimony of the parties. And Mr. Papotto's, put a lot of weight on only 4 questions being asked to Officer Bonfield. And again, Officer Bonfield wasn't a direct eyewitness to the case.
Were any of the body
Yes.
cameras, and 4 body cameras, did any of them catch anything of the actual
No,
event?
they
So
came
none of those
after-
people none of those officers were there, and none of their
No.
cameras caught anything of the event?
Exactly, Your Honor. They came after the incident was over. They were called. They interviewed both parties. Those interviews are on the body cams.
When the interviews
Were available to defendant to present whatever he wanted during the course of the trial. And again, even if you'll notice in the record, Mr. Papotto even was directing counsel to play certain videos, and that was done during the course of the trial. He asked for, it was Officer Zidwicki's body cam to be played, and that was played during the course of the trial. So I think, he can't, by law, demonstrate the ineffective assistance of counsel claim. Thanks.
Thank you. You may come up to the podium, you have 4 minutes.
Well, I don't know if what I'm saying is relevant or not, but I was told that they were gonna show Zombach's body cam only. Now, he has no idea that, because that's what Tim Corley told me what was gonna happen. And I said, well, what about Bonfield? His body cam shows him doing the casino a favor because I'm an asshole, they think. Okay, you can think that if you want. My sugar was 544. A month after that, the doctor said I was in a diabetic coma. I should have been, but it was 384 average for 3 months. Well, to say I'm walking aggressively, well, I'm in pain, constant pain. He has no, and he says, and others. He doesn't know what other people think that are in line.
But the only camera that actually caught the actual event was
Was
the
the
casino
thing.
camera.
It
Okay.
was and it's hard to open, and the reason I'm doing what I'm doing in the courtroom, because I'm trying to help them open up the camera. I open up the video, and I wrote down how to
But the
do
court
it.
actually saw the video, right?
Me?
The judge saw the video.
You'll see in her testimony, I've seen enough. You but be quiet. She told me to be
And
quiet.
that's on the transcript.
Yes, it is, man. Yes, it is, Your Honor. I'm trying to ask this guy that's appointed to represent me at that point, they told me this is what was gonna happen. I had the opportunity, since he decided to charge me with a more serious crime to try and scare me, I told the judge, you can't scare me with jail from telling the truth. That's in the transcript. So why would I say that if she didn't tell me I was gonna go to jail?
Well, if they're only trying a minor misdemeanor, there's no jail time on a minor misdemeanor.
That was before, and all that stuff that's scripted on the record, she included that, but she threatened me with jail. That I better get out there and take that plea deal. I said, no, I'm not doing it.
When you were still charged with the first degree misdemeanor. She,
Yeah.
you're alleging she threatened you with jail when you were charged with First Amendment.
I was, and I
first
told her,
degree
you can't
misdemeanor.
scare me with jail from telling the truth. I'm gonna tell the truth. Then, so the jury wouldn't see the evidence. The state chose, like you said, to take it upon himself and then charge me with the jury fees. But the camera thing is hard to open. You gotta, on the middle thing, it's gotta go telco export player. It's in the middle, you know, when you click on the thing, the one in the middle shows up. Then you gotta go to the far right where it says view video. Okay, now that'll open up the camera. Then there's so many different options you can do. You can move your cursor for that thing, that arrow to the right and hit enlarge. Well, that'll blow it up. And then there's a screen in a screen that'll be a red box on there. Well, you can click that and it'll magnify everything.
So this is the one that's in the record though now?
It should be, along with Zombach and Zindiggy's body cam. She wouldn't watch the whole thing. She was in too much of a hurry for her tickets she had for a conference that were paid for. She wasn't gonna miss because of me. When you blow that up, he hits me 6 times first before, I still had my ticket and my water in my hand. I moved my water over to this hand or my ticket, and I moved his arm out of the way, because that's a boxing move. He raised his arm up to measure me, and you'll see his right hand coming up. And when I saw that, I knocked his hand and gave him a shove on the shoulder. My hands are wide open. You can see that. You can zoom it up, see it. He hit me, then I hit him, and he went down, fell down or knocked backwards, and attacked me again. Everything I did was defensive. So in a trial, he's trying to make it like, oh, you're a boxer, you know, well, it's a great sport, I loved it. I played football, baseball,
And I'm sorry, but your time
See?
is up.
I'm way off base, but